Good afternoon, and a very warm welcome to this webinar on the EU Charter of Fundamental Rights in Practice, Strengthening Fundamental Rights Protection in Europe. My name is Philippe de Man. I am a research manager and senior researcher at the Leuven Center for Global Governance Studies at KU Leuven, and I will have the pleasure of moderating today's webinar. Today is the third and final webinar in our series that marks the launch of the online course, From Theory to Practice, Applying the Charter of Fundamental Rights of the European Union. A couple of words about this course. Our center developed the course together with the European Commission, DG Just, and with the invaluable support of about 20 external experts on Charter. The aim has been to create a learning resource that is both, let's say, legally sound and also practically very useful. So not just explaining the Charter as a legal instrument, but also really helping practitioners understand it and understand how it can be applied in specific, let's say, legal and policy contexts. The course is hosted on EU Academy, and it consists of 53 modules. So basically a dedicated module on each of the fundamental rights and principles contained in the Charter, and additionally 3 introductory and cross-cutting modules on the course, on the Charter, and on the general provisions of the Charter as well, which are, of course, crucial to understand its scope, its interpretation, and its application. Now, the first webinar in this series, which took place 2 weeks ago on the 27th of May, marked the actual launch of the Massive Open Online Course, or MOOC, as we call it, and it introduced the online course as a practical learning resource for applying the Charter. The second webinar, which took place last week on the 4th of June, focused more specifically on fundamental rights in impact assessments and the use of the Better Regulation Toolbox in policymaking and legislative processes. Today's webinar takes a bit of a broader and I think more reflective perspective. We have invited 4 excellent panelists to speak and reflect on any or all of a number of questions. So these questions concern the role and added value of the Charter alongside other international and regional human rights instruments, the main achievements of the Charter, what are some of the key challenges for the Charter looking forward, how can the Charter better be used in the future, and what needs to be done by whom to achieve this, and finally, how can individuals be further empowered to uphold the Charter as well. Now, before introducing our esteemed panel, just a few practical points. Today's webinar will be structured around presentations by our 4 speakers, who will all address these questions from their own professional perspectives. If time allows, we will afterwards then have a short discussion based on questions from the audience. So we do invite you to submit questions throughout the webinar using the Q&A function on Zoom. So we will collect those questions during the presentations, and as I mentioned, depending on the time remaining, we will bring a selection of these questions into the discussion at the end. So we're very pleased to have an excellent panel with us today, bringing together perspectives from the European Commission, from the EU Agency for Fundamental Rights, from national human rights institutions, and from academia. So we are joined by first Ms. Rosalba Striani, who's acting head of unit for fundamental rights policy and free movement at the European Commission DG Just, by Dr. Gabriel Toggenburg, who is a senior legal advisor at the European Union Agency for Fundamental Rights, by Ms. Debbie Kona, who is the Secretary General of the European Network of National Human Rights Institutions, and by Dr. Joel Grogan, who is a legal academic and expert in EU law, public law, and the rule of law. I will introduce each speaker a bit more fully when I give them the floor. So without further ado, I'm very pleased to first give the floor to Ms. Rosalba Striani. So Ms. Striani, as I mentioned, is acting head of unit for fundamental rights policy and free movement in DG Just. Before taking up this role, she served as a political assistant to the Director General of DG Just, and her main areas of expertise concern civil justice, criminal justice, the rule of law, and fundamental rights, including data protection. So I think Ms. Striani's perspective is, of course, especially important for today's webinar because the Charter is, as I've mentioned, not just a, let's say, a judicial instrument. It also has to be applied upstream, right, in the preparation of legislation, in policymaking, in implementation, and in the day-to-day work of EU institutions as well. So, as I mentioned, Ms. Striani, the floor is yours.
Thank you very much, Philip, and thank you for this introduction. I'm very happy today to represent the European Commission on this final webinar launching the online course on the Charter of Fundamental Rights. This course has been in the pipeline for a long time, and I thank and congratulate all those involved in making this course to become a reality. I'd like also to convey my gratitude and appreciation to the team from Q11 for organizing this series of launch webinars, as well as to all of those who took part in the webinar. For the European Commission, the Charter, as you mentioned, is a crucial reference point, and we continue to make the efforts to ensure it is respected in all fields of EU policy. The Commission sees the Charter as both a compass and a very practical tool. As a compass, the Charter guides all EU institutions, as well as member states. It imposes an obligation on both the EU and the member states whenever they implement EU law to promote and protect the rights it encapsulates. As I mentioned, the Charter is also used as a tool for us. In fact, the proclamation of the Charter and its inclusion in the primary EU law resulted in the implementation of 2 consecutive Charter strategy with their tangible goals and commitment. For example, the adoption of annual Charter reports or establishment of Charter focal points, the network which was a couple of days ago completed. The necessity of compliance of legislative proposal with the Charter is also crucial to checks carried out by the Commission throughout the legislative procedure. That means not only carrying out impact assessment that you have already heard in the last webinar, but also conducting stakeholders consultation, ensuring that relevant proposal include recital explaining compliance with the Charter and working with the co-legislator to ensure that EU law is in line with the Charter. It is also crucial to mention the role that throughout the years the Charter has played in the jurisprudence of the Court of Justice, leaving its mark on a remarkable body of case law and making a difference in the lives of people in the EU. For example, recently the court ruled that by adopting a law which stigmatized and marginalized LGBTIQ person, Hungary had acted in breach of Article 1, Article 7, 11, and 21 of the Charter. The court also established for the first time in this landmark judgment a self-standing violation of Article 2, which sets out the EU values. And the Commission is reflecting on this court judgment and the implementation of it. In another case, the court stated that refusing recognition of same-sex marriage lawfully concluded in another member state violate fundamental EU rights and principles, including freedom of movement, respect of private and family life, and non-discrimination. So, as it is evident from its text, as well as the decision of the court, the Charter operates within a multi-layered legal system. Alongside national constitutional guarantees, the European Convention on Human Rights and international human rights instrument. But rather than replacing this framework, the Charter complements them and helps ensure a coherent and high level of protection across the EU. After the EU's eventual accession to the European Convention on Human Rights, we need to guarantee that the Charter and the Convention are applied jointly and that we maximize the complementarity of these 2 systems. The Charter provides a single, coherent framework of rights that guides both legislation and policymaking across the Union. It is a forward-looking legal instrument for us. When proclaimed in 2000, it brought forward several innovations. For example, in the context of the right to integrity of a person and the resulting prohibition of the reproductive cloning of human beings. The Charter has also been a pioneer instrument by expressly referring to groups who at the time when the Charter was drafted did not have specific instrument of protection under international human rights law. For example, older person with disability, and sexual minority. What makes the Charter particularly important today is its modern nature. Alongside traditional civil and political rights, it includes protections highly relevant to contemporary challenges, such as data protection, freedom of expression online, non-discrimination, and access to justice. At the time of major geopolitical and technological change, the Charter ensures that EU action remains grounded in fundamental rights and the rule of law. Ultimately, it embodies the value on which the European Union is built and keeps fundamental rights at the center of European action. As pointed out in last year's midterm review of the Charter strategy, the Commission considers it crucial to do more to improve the Charter implementation and application, both at EU level and in the Member States. The consultation for the midterm review underlined that efforts to further strengthen the application of the Charter must remain a priority. The level of implementation of the Charter across Member States remain uneven, and the national administration and the wider public often lack sufficient knowledge of the Charter rights and remedies. This problem also persists among the judiciary. Judges and other justice practitioners apply the Charter in court and have a unique role in ensuring the applicability of fundamental rights. However, availability of judicial training and information on the Charter remain low. Against this background, providing and promoting targeted training for national administration and the judiciary, coupled with the exchange of best practices and awareness campaign, is a crucial element for ensuring the Charter's effective implementation. In this context, during the first launch webinar, the import of this online course on the Charter has been emphasized also by our Director General. So let me once again stress how much we hope that this course helps to address the knowledge gap. It is also important to remember that one of the key conclusions of last year's Charter report is that protection and promotion of fundamental rights are shared responsibility. Cooperation between EU institutions and Member States need to be strengthened if we want to remain on the path of effective implementation. Of course, here the EU institutions, bodies, office and agency have a very significant role. Apart from the Commission's role in ensuring compatibility of legislation and policy with the Charter, the institution needs to continue to use all available tools to support the Member States in fulfilling their Charter commitment. Among the relevant actors who can all help to contribute to effective implementation both in the EU and national context is civil society, whose important role has been emphasized in the 2022 Charter report and elaborated in the adoption of the strategy in 2025 on civil society. Moreover, as the midterm report points out, independent human rights bodies are particularly well placed to share information, help people access judicial protection when their fundamental rights are violated, and this is why the Commission has decided to focus the 2026 Charter report on national human rights institutions, equality bodies, and Ombudsman institutions to explore their role in supporting application and implementation of the Charter. The Commission realized that the awareness and practical understanding of the Charter remain essential to ensure that it is effectively used by citizens and practitioners in daily life. In the Eurobarometer survey on Charter knowledge carried out in spring 2025, only 49% of the people had heard about the Charter, and only 12% of the respondents felt well informed about their rights under the Charter, indicating a further need to raise awareness. Moreover, over 6 out of 10 respondents would like to get more information on where to turn if their rights are violated, on the content of the Charter, and on when not the Charter applies. We consider the gaps in such awareness and understanding to be one of the key challenges to realizing the full potential of the Charter, and we hope to collaborate with all the relevant stakeholders to effectively address this gap. Our common intention must be to move from general awareness toward practical application. This means strengthening training for those who apply the Charter directly, judges, legal practitioners, public administration officials, and enforcement bodies, so that it becomes a working tool in their daily decision-making, not only a legal preference. At the same time, accessible and practical information for citizens is important so that people know when and how the Charter protects them. Another common intention should be ensuring that the Charter and our policy effectively respond and adapt to modern challenges like digitalization, the rise of AI, climate change, misinformation, and polarization. In this regard, the Charter should remain a living instrument, one on which we can constantly and consistently rely in today's fast-paced modern world. I would like to thank you very much for your attention, and I hope that this provides some grounds for reflection and discussion.
Thank you so much, Mr. Riani, for these wonderful insights. They are definitely useful to kick off the discussion with the other panelists, no doubt. They gave a good overview, I think, also of the current state of play and the challenges that are ahead. I think one of the challenges that you've mentioned is, of course, that member states should be given all the tools and should be assisted wherever possible to indeed be able to fulfill their commitments under the charter. And I think this is where our next speaker would definitely be able to contribute some keen insights. So for our next speaker, we have Ms. Debbie Kona. So she's a Secretary General of the European Network of National Human Rights Institutions. This network brings together national human rights institutions across Europe, which are independent bodies established to promote and protect human rights at national level. So as we have heard from Mr. Riani, I think Ms. Kona's perspective will definitely be essential for today's webinar, since the Charter's effectiveness depends not only on EU institutions and courts, but also on whether it's actually known and used and applied at national level by, let's say, all relevant actors. And I think the national human rights institutions can play a very important role. So please, Ms. Kona, the floor is yours.
Thank you very much, Philip, and congratulations to you and colleagues at KU Leuven and the Commission and everyone involved on producing this excellent training course. I think there was a great need and you've done a wonderful job. I can see already how it will respond to some of the needs that Rosalba has already mentioned. As you said, I'm here from ENRI, the European Network of National Human Rights Institutions. And so I will answer your 5 questions, really keeping in mind the views of NHRIs. And luckily, as the Charter report will be on NHRIs this year, I have fresh information from NHRIs from all over the EU in order to let you know what they feel is going well and maybe could be improved. First of all, in case there isn't awareness of NHRIs, National Human Rights Institutions, as Philip said, they're state-mandated bodies, but they are independent of government and they have a very broad human rights mandate to promote and protect human rights. So when they are working with the Charter at national level, they will be advising the government, parliamentarians, state authorities on compliance with the Charter for draft legislation, policies, likely impacts, and they'll be monitoring thereafter the application of laws and the extent to which there is compliance, the overall human rights situation, including in relation to the Charter. They report on the human rights situation to the public, to Parliament, and to international bodies. And they also work with individuals in different ways. Some have complaints handling mandates, some provide legal assistance, some use litigation using the courts to help individuals to enforce their rights, used in a strategic way so that structural issues can be addressed. And finally, as they are promoting human rights as well, they are providing awareness raising, human rights education, including to state bodies, and really helping to create a culture of rights. Now, while these are national bodies, part of their role is to engage with the international level of human rights mechanisms. So, first of all, through ENRI, our members are engaging on EU policy, and so looking at compliance of EU policy and legislation with the Charter. And furthermore, they have chosen for their membership network to use their human rights monitoring to report on rule of law, also to the European Commission as well, also to look at mis and disinformation, supporting the Democracy Shield, and supporting civic space. So these institutions really look at the Charter as a key component, but interdependent with the other EU values, which is really helping overall to produce, well, to work towards an EU that is respecting rule of law, democracy, and of course, fundamental rights. So in doing this, they are, of course, as I said, providing information to the EU level, which helps the institutions to understand the national situation. But they're also local experts helping to implement the international standards, in this case, the Charter. Now, Philip, you were asking about the complementarity with other human rights instruments. And as NHRIs work on all human rights, it means that their day-to-day work is looking at the same time at the Charter, the European Convention on Human Rights, and other Council of Europe instruments, as well as the UN treaties. And of course, the Constitution and any other rights-based mechanisms. So in doing this, it is not a question of choosing one or the other. They really use them all together, and then they look to see what will be the most effective and efficient way to ensure the respect of rights and to give individuals the opportunity to enforce them. So it will depend what they're working on for which instrument is used most. They will often mention several of them. Of course, ECHR and UN treaties have the benefit of applying to everything, not just within the scope of EU law. But we know that the Charter has stronger enforcement. It has more modern rights, as we heard from Rosalba, and there's an increasing body of case law, which is really helping NHRIs to work more in this area. We heard from members that they often work specifically with the EU Charter when looking at the compliance of EU law, of course, looking at human rights impact assessments for transposing EU directives into legislation, and in specific areas where there is a lot of EU legislation, such as migration. We have found that from our members, but also from our secretariat based in Brussels, that the Charter really has had an impact on the EU. We have seen that there is a stronger rights-based culture in the EU and also in EU policy and legislation that has impacts on the national level. I'd like to use a few examples. Well, we've already said about the case law, the modern rights that are included. I won't repeat them as Rosalba did so well, but that has inspired new legislation, whether it's on GDPR, Digital Services Act, media freedom, etc. Now, the Fundamental Rights Unit, Rosalba's unit, recently published updated guidance on human rights impact assessments for the European Commission to use. And this is incredibly important, and having that visible and mainstreamed and used also helps to ensure a stronger rights-based culture. And we have seen in many policy areas where the Charter has been mainstreamed, whether it's in the Democracy Shield, the AI Act, where many NHRIs are actually designated as protection bodies for fundamental rights under Article 77. In the internal security policy, looking at migration, there is, of course, the independent monitoring mechanisms, which look at fundamental rights under the screening regulation. And even in the use of EU funds, many of our member institutions are designated to apply the enabling conditions under CPR, checking that the use of EU funds is in line with the Charter. And indeed, that could go further with conditionality proposed in the new MFF. Now, there is more linking we can see between the national and EU level, but sadly, all of these developments don't go far enough. While this wonderful guidance is out on human rights impact assessments, we are aware that it is rarely used, sadly, and even when used, not in a meaningful way. NHRIs can also provide information of the likely impacts of EU legislation from national level, and really more needs to be done. FRA could also provide some good information. Also, although fundamental rights are included in all of these policies that I have mentioned and even EU legislation, sadly, it is often more in name than in practice, or not systematic, or there's insufficient clarity or even rollback. So while in the internal security policy, Democracy Shield, it is included that the Charter and fundamental rights need to be respected, there is no indication of how this will be done. In the rule of law reporting, the Charter is included more, but sadly we still do see some silos between them. And For the independent monitoring mechanisms under migration, there is a real lack of clarity. So the NHRIs who are designated are still not clear on the role, don't necessarily have the capacity, the expertise, the resources, and of course this is coming into force on Friday. Even worse, we've seen in the AI Act and CSDDD that there has been rollback with the omnibus simplification agenda really taking away the application of fundamental rights and respect to the Charter that we saw before. Even in the communication on better regulation, we've seen that in urgency, human rights impact assessments or any impact assessment might not be needed. So these are some areas that I believe that could be looked at. And looking more now to the national level, our members have said that really there are two main problems. One is the complexity, and here it's looking at when is a piece of legislation within the scope of EU law, and this is where training is needed. Rosalba has already mentioned whether it's judges, legal professionals, national authorities, CSOs. NHRIs can help with that training through their mandates, but they also need training themselves. And this is where MOOC, again, is an excellent tool to be used. Our members also have said there could be more dialogue between the Court of Justice of the EU and the national courts, and even interpretive guidance to help in the implementation. And that brings me finally to the lack of awareness. Rosalba has mentioned it, and it is improving, but it's clearly still low. We found our members, some of them don't even know who the Charter focal points are, and a lot of individuals, as we heard, over 50% haven't heard of the Charter. And this is important because fundamentally, the Charter is about individuals. It is about protecting individuals' fundamental rights. And so it is important they are aware. CSOs, NHRIs can help as well, but really with the backsliding on fundamental rights, democracy and rule of law, really we need everyone to join together. It takes not only a village, it takes a very large city, because as I really believe that we need some leadership from the EU institutions to show that they are walking the talk. We need member states to step up and independent institutions like NHRIs to really push them in that direction. We need greater awareness and training for all stakeholders involved. And I do think that this training course is an excellent opportunity to get more individuals involved, no matter what their background, be it legal, civil society, or just being a citizen in the EU. So thank you very much, and apologies if I've gone over time with it. Thank you.
Thank you so much, Debbie, for your insights. I don't think you have gone over time, so thank you so much. And I think I remember a lot of things from your talk, but let's say some of the key points I think are that there's, let's say, a complex reality on the ground, that the Charter is one of many instruments, but an important one. And that, let's say, the cooperation between member states and the European Union has improved recently quite a bit, but that there's still a number of challenges that need to be addressed. And one institution, of course, that you mentioned by name is the FRA, that has this very specific role to play here. So that gives me an opportunity to introduce our next speaker. So our next speaker is Dr. Gabriel Toggenburg. He is a senior legal advisor at the European Union Agency for Fundamental Rights, or the FRA. He's also honorary professor for European Union and Human Rights Law at the University of Graz. So Gabriel's worked extensively, of course, on the Charter, on EU fundamental rights law, and is quite knowledgeable, obviously, on the role of the FRA in supporting EU institutions, member states, and practitioners in giving quite practical effects to fundamental rights. So I think his perspective is especially valuable as well, since the FRA works at the intersection between, let's say, legal standards, evidence, practice, and practical guidance. And of course, that makes the FRA a very important actor in translating this Charter from, let's say, a legal text into something that can be used by institutions and by rights holders as well. So please, Mr. Toggenburg, the floor is yours.
Thank you very much, Philip, for the invite. And let me also start by firstly congratulating both the Commission as well as you, Philip, for the new training tools. I looked at them and I really think they are super useful. So everyone who is listening to us and who didn't yet jump at the online components or at the manual, do so. I think it's worthwhile, really a good contribution. And the second introductory remark is maybe just a caveat that I sort of will rather erratically try to pick up what was said before beautifully by Rosalba and by Debbie. So when I happen to speak about the charter, I'm always a bit hesitant to understand what should be my red line or key message, because if we stare at the charter, it's really like a glass where we don't understand, is it actually half full or is it half empty? And there's, especially for those that have been working on the charter a bit longer, there is sort of a frustration involved with the charter, right? And some people would even go so far to say this frustration is permanent because it is inherent in the constitutional nature of the European Union. If you have a federal entity that has only limited competences that are shared with the member states, and only there they are having the power to bind the member states, then you will be eternally frustrated with the lack of take-up of the charter. Now, I slightly contest that take, because I think you have a similar situation with every rather new human rights document. They never, they're never born and in the next day they are already a living document. It takes a while till the legal system picks up the dynamic of a new text. In fact, we had the very same phenomena in Canada, where you might remember in Canada they have an instrument that has exactly the same title as our charter. And there also that was sort of an instrument born at federal level, and there was no pickup at provincial level for long years. And then what the Canadian government did was to invest heavily in strategic litigation to ensure that lawyers at province level use that instrument and bring it alive. And I think that is also something we will have to do in Europe. Basically, it's also difficult to talk of the charter because you have to decide what aspect you pick out. There are at least 4 dimensions of asymmetry. So there's an asymmetry in the use of the charter at EU level and at national level. At EU level, it's highly developed, and you know that the current president of the Court of Justice referred to the charter as one of the most developments of the history of the process of European integration. And then a general advocate in one of his books said that at national level, the use of the charter is frustrating, piecemeal, and unconvincing. So there's a huge discrepancy in that regard. And then at national level, you also have an asymmetry between the 3 branches of governance, where the judiciary indeed over the years has picked up the instrument. And there are some constitutional courts that use the charter as their own co-owned constitutional benchmark, just referring to Berlin and Vienna as 2 examples. But the other 3 actors in the national systems, governments and parliaments, actually are quite hesitant to really engage with the charter. You then certainly have also an asymmetry in policy areas. So in some policy areas, the charter is also at national level quite prominent. Take data protection, asylum, discrimination. So in all those cases where you have strong EU legislation, legal practitioners feel more reassured that the Article 51 test is an easy one, and then they go for it. But in other areas, you have total absence, even in those cases where there is very strong case law. And if we all agree that 2/3 of national law and policy making is directly or indirectly influenced by EU legislation, we would expect far more cases dealing with the charter at national level and far more legal instruments engaging with the charter. I mean, that the problem already starts in the lawmaking process, where we see, and we showed that in a recent report, that the procedural provisions at national level on human rights impact assessment, they hardly refer to the charter. There's a handful of member states that refer to the charter in these procedural provisions. So it's no wonder that people overlook this instrument. And finally, there's an asymmetry between rights. You have some super performers. So just this morning, I looked up the figures. So from 1st of December 2009 to today, we had 3,732 judgments by the Court of Justice that used the Charter either in the grounds of the judgments or in the reasoning. And if you then look at the breakdown of rights, it's really interesting to see. So Article 47 has been referred to in 1,052 judgments, but then you have other charter rights that haven't been referred to in a single judgment. And there's also a discrepancy between political and civil rights and social and economic rights, with the social economic rights even at EU level being actually ignored a bit in the judiciary. Another super performer, by the way, is the right to good administration, the right to property, non-discrimination, family life, data protection, and the right to run a business. So this asymmetry just from the very beginning. A second point I would like to make is that we shouldn't only stare at the European Union. I think there is a role for the Charter outside the EU law context, and that's often overlooked. I mean, the Charter provides us a new consolidated fundamental rights language that combines, as you know, social rights and economic rights with civil and political rights. And the preamble itself says that it's meant to strengthen the protection of rights in the light of changes in society, social progress, and scientific and technological development. So basically, the Charter is also measuring a bit the human rights developments for the whole continent. And it's not a surprise that the Strasbourg Court has referred in very important cases to the Charter, and the Charter thereby is also influencing the Council of Europe system. That is another element that we shouldn't forget, right? We have maybe another 10 years till the two systems might come even closer. So we should focus our intellectual energies also on the interrelationship between the two systems. What is the role then for the Charter for the EU and the member states? Obviously, the Charter says that the major role is to make the rights more visible. And that is important from the constitutional nature of the European Union, because the citizen needs to understand what sort of rights they have. And secondly, it's of course the basis for mutual trust and mutual recognition that there's a consensus that the European Union itself provides these protections. Just to think back of the genesis of fundamental rights, we all recall that the court sort of established fundamental rights in order to save the two holy cows of EU law, direct effect and supremacy. And that, I think we shouldn't forget why it is important that we have these rights. But turning to the future, what needs to change to sort of increase the momentum? Maybe 4 points. One is that I think we need to know more. We don't know so much what happens in the national system. So a broader monitoring of what happens would be useful. Of course, we do that a bit, but I have to admit that our annual monitoring, if you want to call it like that, in our fundamental rights report has an inbuilt positive bias, because we actually look at cases where the Charter has been used. But it would be interesting to understand better where the Charter has not been used, but should have been used. Then the second point maybe is strengthening national implementation structures. And I totally agree with Debbie that it's of course key that individuals have structures in place where they can invoke their rights. I mean, this is not only about the Charter, that's also about the ECHR and the national catalogs. You need the machinery in place that all this works, and the non-judicial machinery. And then of course, the courts and the legal practitioners, they need to be strengthened. We should talk again to the training academies to ensure that when a young lawyer enters the system, that she or he gets a solid training on the Charter, which is not yet the case, as we know. I also believe that the networks of the court coordinators on EU law, which some member states have. So basically, these are judges that are specialized in European Union law, and they coordinate in the courts the cases that are related to European Union law. And I think these are perfect entry points for having a targeted training, and ask them also to ensure that whenever they deal with cases, they have a Charter look, or that they put on Charter glasses. And my last point then maybe would be the funding. Going back to the example of Canada, what I said at the beginning, I think we have to provide funding to those actors that sort of provide for the dynamic development of the law at national level, and that is barristers, right? Because they bring the cases to the judges. We always tend to think of the judge as running the show, but in most cases, actually, it's the ghostwriters are not the judges, but the people who bring the case to the judges. So funding legal associations, civil society organizations that do strategic litigation will be key. And I stop with this, just saying that we are currently carrying out at the FRA a project in all the member states, currently in 17, but we will expand to the others, where we try to convince in partnership with the Charter focal points, the NHRIs, the equality bodies, the government, to offer a model training to legal practitioners in the hope that we reach out to multipliers. And of course, when we do that, we will also, and that's addressed to Philip and Rosalba, we will also tell them that they should, of course, promote the new tools that you have provided. And thanks again for having done that. Thanks.
Thank you so much, Gabriel, for your contributions. I think adding yet another layer, let's say, of nuance to the discussion, that if we're talking about the Charter, it's not just about one single document, it's really talking about 50 different rights and principles, and that some of these are, let's say, translated into practice a lot more than others maybe, and that there's an asymmetry at a lot of levels in that regard. I don't want to take up too much time anymore because we have one more speaker and want to give some time for questions as well. So I would be happy now to give the floor to our next and final speaker, who is Dr. Joelle Grogan. So Dr. Grogan is legal academic, broadcaster, and expert on the rule of law. She has been since 2023, I believe, academic co-director of the Rule of Law Clinic at the CEU Democracy Institute in Budapest. And she's also a visiting senior research fellow at the UCD Sutherland School of Law. And last but not least, she's also presenter of The Law Show, which is a BBC Radio 4 radio program and podcast that helps listeners understand legal issues behind the headlines and how law affects people's lives. So I think she's very well placed final panelist. She's also one of the key external experts that has contributed to the development of this online course. So she would bring, I think, both a broader academic perspective and also a direct familiarity with the aims and structure of the MOOC itself. So please, Joelle, the floor is yours.
Thank you so much. And as a first point, I really need to give such credit and laud the Leuven Center for Club Governance for this really incredible course. It was such a privilege to be involved with. And I know as an academic, I always like to give the impression that I know everything about everything all at once. But being part of this course and really engaging with the Charter of Fundamental Rights opened my eyes to so many of the not only successes of the Charter, but also its issues and where we can all work together on things. I also recognize that my position as the final speaker means that I also have the great privilege of just repeating and underlining so much of what we've just heard and echoing so much of what we've just heard. But perhaps my USP as an academic and using my radio voice, my BBC radio voice, is to actually think a lot about the language of rights. My job, my work is to make law accessible, to make the rule of law and fundamental rights accessible. And a lot of what I have now understood within the context of the Charter is not only that it is accessible, that the rights that we have just feel innately accessible, but the translation is difficult. Making it real to ordinary citizens and ordinary people is difficult. This can be institutional, this can be in terms of the complexity of law and engaging with institutions, but it can also just be ordinary. The average person that I meet thinks we all have the right to free speech. So I had a lot of fun last week trying to explain to an American audience what the freedom of expression means in that context. But what I thought would be most useful in terms of my final contribution, again, not just to echo what we've just heard, is to talk about some of what I consider to be the macro, the very big challenges to the Charter of Fundamental Rights and its implementation, right down to some of the micro challenges, the individual challenges, and then also think about some of the ways in which we can collectively move forward. This, in large part, is obviously going to be informed by my own work here in the UK and what I've seen in terms of how the ECHR, the European Convention on Human Rights, has successfully been implemented in some ways, but also now its challenges, again, with the idea of the language of rights. So right now, and I don't say this in any way dramatically, we're all very aware of this, we're facing crises on a scale that we haven't really seen before. We're talking about the challenges of migration, of climate, of AI, of technology, of cost of living in a way that really has become very immediate to the ordinary citizen. And the expectation of rights, and we have an incredible Charter of Fundamental Rights in how modern it is, that it does really look forward and try and engage with digital rights, engage with data-driven rights, but also engage with the challenges of climate, of migration, of other issues, is that for a lot of ordinary people and a lot of politicians, a lot of people engaging institutionally with these great challenges, these socioeconomic and geopolitical challenges, is that rights can feel like a hindrance. They can feel like something that stops effective action, that gives power to the undeserving minority. That's something I hear so often in the context of many of these challenging debates, both within the EU, but also here in London. Now, one of the ways in which we have to move forward in this is instead of seeing rights as a challenge or a hindrance, but actually as a language to help us navigate these challenges, to help us navigate our legislative agenda, to evaluate, to consider it, and to understand it. But as I will only echo the other speakers, this requires understanding. This requires reframing the debate. This requires the ordinary administrator, the ordinary politician. No politician is ordinary, I can't say that. But the ordinary people engaged with this decision-making to understand those rights, to understand the ideas of legality, of proportionality, of necessity, and of what we're really trying to protect when we protect these values, when we protect these rights. So, of course, I'm going to echo the importance of training and this fantastic MOOC that is available. But I'm also going to push forward and say there are still ongoing institutional challenges, which I think Debbie outlined so wonderfully and so beautifully. A lot of these institutional challenges are access. They're just access to justice. One of the great crises that we experience across the EU is a lack of legal aid. It's the lack of capacity of the ordinary person to even just get advice on what rights there are available to them. This is not just within the scope of EU law, and that is a challenge to the Charter of Fundamental Rights, that we do have that narrow scope of implementation, but it's also just the accessibility of the ordinary citizen to understand their rights, and if their rights are violated, to be able to take it forward through the courts. We have ongoing challenges in terms of rule of law in so many member states, and we've already talked about that, this uneven implementation, but this uneven accessibility, this uneven institutional knowledge, but the unevenness of institutional resources. If we don't effectively resource our justice system, but also if we don't effectively support our civil society, then there's no way that we can talk in any serious way about rights. I'm so sorry. I have a 6-month-old baby that was meant to be asleep right now, but it's not, you're never young enough to learn about rights. But ultimately, if we do look forward and we look at these institutional challenges, it's not just a matter of throwing money at those important civil society organizations or trying to concentrate very hard when a baby is looking at you in a very cute manner. But it's instead to change that debate around rights and the importance of rights, that the importance of rights are not just in the minority suffering, but in the whole population, in the whole country, taking benefit from having rights integrated at the level of legislation at EU level, within member states in the way that they think about policymaking, but also just in the ordinary lived existence of every citizen and resident in the EU. And on that note, and my daughter reaching desperately out for my phone, I'm going to pass back to Philip.
Thank you so much, Joelle. And it's always good to see that the future generations also take an active interest in fundamental rights and in human rights. So definitely a welcome addition to the panel, I believe. We have about 11 more minutes for some questions for discussion. I understand, of course, that all the panelists would love to react to what has been said by other panelists, but I also want to give the floor, or at least give the opportunity to raise some questions that were asked in the chat. Some of those were directed at specific panelists, others are more general. So Maybe I'll just start off with the first question that we received. I believe it's mainly directed at Ms. Kona, but it could be, I think, addressed by anybody who really wants to add on to this. So the question is, why is it that only some NHRIs appear to have the power to support individual complaints? Because they understood correctly that some NHRIs have such powers from your talk, Debbie. So that's essentially the question, and follow-up question is, how do NHRIs then enforce individual rights or litigation? Please.
Thank you very much for that question. NHRIs are tested to see their independence, but also to check that they fulfill international standards called the Paris Principles, the UN Paris Principles. Now, in the Paris Principles, there are certain requirements, such as each NHRI must work with all human rights. They also must protect human rights, but that's not enough. They need to promote as well. But there are different ways of protecting human rights. And for some NHRIs, they do have individual complaints handling. And in Europe, for example, often it's those that also have the ombuds mandate. But it is not essential. And so an institution can still get accreditation and be an NHRI without that function. However, with the variety of NHRIs across Europe, there are other ways that they can look at enforcement. And some NHRIs actually have the right to take litigation, to bring a case to court on behalf of an individual whose rights they believe have been violated. And as I said before, it's often done in a strategic manner. Some NHRIs also provide legal assistance, so they support individuals to bring a case to the courts themselves. And there are also some grants and other ways in which individuals can be supported. And if there's any lack of clarity, FRA has an excellent overview of the different institutions, because if an NHRI doesn't provide individual complaints handling, A, it will be able to support in other ways, and B, they will also be able to direct you to the correct institution to receive a complaint if needed. I'd like to add just two small points on this. And one is to really underline the monitoring and reporting, which can actually help to deal with structural human rights issues by reporting to Parliament, by ensuring that the advice to government takes into account. And actually that not only can help solve the overall issue for citizens, it can be used also to prevent human rights violations, which I think is important as well. Interestingly, for the Charter, it doesn't really have the same mechanisms for NHRIs to report on their monitoring that you have with many UN and Council of Europe instruments. And then secondly, on litigation, a final way that NHRIs use litigation is by bringing third-party interventions. And here, as an amicus, they can provide information that provides actually also a lot of coherence in looking at the different human rights standards to help the court come to its decision. And interestingly, before the European Court of Human Rights, our members often intervene before the court, and we even intervene as a network. But it's much more difficult to do that for the Charter, because to be amicus, you need to be a third-party intervener at national level, which of course would be unlikely for a network. So that's two interesting ways where, although the Charter is so strong and stronger in enforcement, it's two ways where there's less access, I think, for NHRIs and others. Thank you.
Thank you very much. I'm sure others have few points in this as well, but I think maybe we can invite other panelists to talk about or to address one of the other questions that's a bit more general in nature. It picks up on what I think Joelle mentioned. So, and the question is, I think, addressed to anybody really. So how do you think the Charter itself can help shift the current anti-rights narratives that are shaping the geopolitical situation and which are hindering any kind of education and awareness-raising initiatives? It's obviously a loaded but very important question, I think. So anybody that wants to speak on this is very welcome.
Maybe I can just start on this and then leave the floor to the others. I think that we have touched upon many effects of the implementation of the Charter, whether it is shaping the policy making, whether it is enforcement of legislation, adoption of the legislation, awareness raising, and training. So I think we do already a lot for promoting the Charter. We really have, from the Commission point of view, a strong commitment also in terms of funding. Also in the next MFF proposal, we have an important pillars that protect the Charter of Fundamental Rights, which I'm referring to the fact that we have a charter conditionality, which is not only anymore related to the Common Provision Regulation, but it's really becoming a structural mechanism in the MFF for the implementation of all the funds. And this is a big shift and very strictly related to the rule of law. So the Agora program that is replacing the SURF has been doubled. So there is really a commitment from the European Union to invest in the promotion of rights. We have done so also by promoting the voice of the holders of rights through the civil society strategy, on which we are engaging directly in a dialogue through the platform and also supporting the civil. So there is a lot from the policy side. But also I want to say that the European Court of Justice is helping us a lot with its judgment, and the judgment against Hungarian child protection law, which by coincidence came very closely to the turning of the government, shows how the action of the Commission toward the systemic issue is upheld by the court in a manner that we have never seen before. So I think that the promotion of those rights by the Court of Justice is also something that is helping the so-called anti-rights movement. So I think, as we have said during this discussion, it's really a joint effort, and from a European point of view, in a moment where there are important and different policy objectives like simplification, defense, digital, we are keeping the path by ensuring that the fundamental rights remain high, that are holding the legitimacy of all this policy, and become complementary, a vehicle to help also this other policy. Thank you.
Thank you so much, Rosalba. We have 3 more minutes in case anybody else wants to chime in on this point.
I mean, I could briefly refer to the survey data we have, because of course we all know this picture that, you know, what one says, well, nowadays people think that human rights are not about themselves, human rights are about the others, and human rights are detrimental to policy making because it's impossible to run a state if you have to respect all these fundamental rights. No, this is an impossibilism that we saw also in Poland. But that is not really backed up by survey data. So when we asked the mainstream population in all the member states, it's true that only 52% were saying that human rights is for everyone. But at the same time, 88% said that human rights are a very good tool to create a just society. And I think there is a huge potential for using human rights for that purpose. And therefore, I was alluding to the underuse of social and economic rights, right? In the moment where you are able to communicate that human rights are also about the unemployed women with 3 children that has been living in the country for 300 years, but she is sort of a key target for human rights policies. That I think will make a difference, and therefore I think yes, human rights can change a bit the discourse.
Thanks so much, Gabriel, for these, I think, concluding remarks from the panel, at least, because we have only 1 minute left. And there's 2 small points for me still to raise. One is to warmly encourage all participants, really, in this webinar to consult and to share the online course that was produced together with DG Just and our external experts. to especially encourage, say, colleagues or trainees or officials, students that work with EU law, anybody really that has an interest in fundamental rights. We have added links in the chat that directly guide you to the online course, and also, I believe, to the training manual, which is a complementary resource for this online source that has been published, I think, just today. So it's really fresh off the presses. And as I mentioned, that's really a very welcome, let's say, additional resource to guide you through the online course, but also can be, let's say, self-standing and has a very, I think, interesting section on impact assessments as well that will be very useful for any kind of practitioner working with fundamental rights. I should also mention that this webinar, like the previous two, has been recorded, and recordings can be found on our website. And there's also a link to the website for our center where you can consult these webinars. For me, the only thing that's left is to, again, thank our speakers, Ms. Rosalba Striani, Dr. Gabriel Toggenburg, Ms. Debbie Conner, and Dr. Jalal Grogan for their time, for their insights. I would also like to thank, of course, all participants for joining us today and for contributing to this webinar series. There were more questions than we could have answered, so there's definitely a lot of interest in this topic, and my apologies that we couldn't answer all the questions. But thank you very much, and we hope the course will be a useful resource in your work. Thank you so much.
All the best. Bye-bye.